Hey everybody, Matt Barton here with this week's Broker Minute or Two. Hey, so a couple weeks ago, my Broker Minute or Two was on property service agreements. These are the deals where companies had come in and would record like 40-year encumbrances on a property saying they were the company that had the right to resell it. We went through House Bill 211 from 2023 that made that go away, at least for ones that were recorded after the bill passed. I may have misspoke in that one. There is no specific retroactive language in that bill. So you're going to want to double check, one, to see if the entity still exists that is required to be paid. If not, kind of hard to pay it if they don't exist. But two, if it does exist, always refer your people to a real estate attorney to see the validity of it. But on its face, if it was recorded before May was the effective date, May 3rd, I think, of 2023, it's still a challenge. And don't fault the title people, because like Barb Twitchell we have from Metro Title, thank you, Barb, for joining us today. Their job, they're the unbiased third party, and they can only go by what is recorded against the property. They're not attorneys. They're not going, it's not their role to step in and give legal opinions, partially because, are you an attorney, Barb?
Not at all.
Yeah, right. So that's why they're not going to weigh in. And even their corporate attorneys are going to say, buyer and seller need to figure out those issues and get the encumbrances moved, because we're not going to insure against something that has a high probability of ending up in a lawsuit. So that's the pragmatic point. All right, so why are we here today? I've asked Barb to join us today because there's another one that's going around, and I'm going to play just this video really quick to introduce this. This was an Instagram that was forwarded to me 3 times this weekend. So let me play this. Hold on. So this is, let's see, Bearded Realtor Utah. Don't know who the guy is, but I've seen him out there a couple times. At least he's got a hat with his logo and his shtick on there, so that's pretty awesome. Let's listen. I'm not going to do the whole thing, but here we go.
1% transfer fees are being added to properties in Utah County, and a lot of them are happening once a property goes under contract. I just had this happen on one of my listings. We went under contract, and shortly after, attorney's law office out of Texas added transfer fee or ownership change fee of 1% to the property and recorded against the property.
Okay, so I'm going to stop there. And Barb, we're going to come back to this, but I wanted to at least show people this is what happens with us a lot, right? In the real estate space, there's these wonderful Facebook and Instagram things, and people get a certain percentage of the information correct, but then there's unintended some misinformation. So Barb, we have one of these documents on a deal you're doing currently. We're not going to expose or share any confidential information, but when was this one recorded against the property?
Initially 2008.
2008. And so it is actually something that's legitimate, and it just so happens this is recorded by a law firm out of Texas. So I wonder if we're talking about the same people. But the first point of clarification I wanted to make was you don't get to record these, especially at the amount he just said, based on some legislation that passed. And so saying that it's recording while they're under contract is a little bit of a misstatement. Your experience, Barb, is we get kind of a reminder notice. What did we call it?
It wasn't a notice.
A notice of
real estate assessment is what they said.
So it's not actually the instrument that was originally recorded. It's reminding people, hey, it looks like you're about ready to transfer ownership, or letting you know we have a claim against the property. Is that a good layman's explanation of it?
Yeah, that's exactly what I'm saying. By the way, don't forget to pay me.
Yeah, don't forget to pay me, because we don't want to have to litigate to get the money that we're owed. So one, I just wanted to tell you, yes, this is a thing, and it is cropping up more, but I wanted to have Barb on here. We're going to go through just really quickly what the legislation is that governs this and some of the rules in regards to it, and then also some of the best practices that we should be utilizing to successfully navigate this. So that's kind of the goal here. Let me pull this up one more second. All right, so here it is. This is Utah Code 57147, and it was effective May 1st, 2024. So this got enacted just last year. And basically what it says is, right, the initial law was passed. If there is a valid recording against a property, then you must reiterate it, restate it every 3 years. Okay, anytime May 1st to May 31st. And there was another provision up here. You must file the required notice by May 31st, do it every 3 years. But it did say your steps need to be determine when it was recorded, check that it satisfied the notice requirements, and see whether notice refiling occurred by May 31st, 2024. Okay, and then also, of course, confirm the fee amount, because in this case, the one that Barb had, it has a 1%. Is that right, Barb? 1%
1%.
transfer fee. And that's okay if it was recorded before this legislation, right? But if it's going to stay valid, it must be restated, and it must be restated every 3 years or re-recorded every 3 years. Now, if there's a private transfer fee covenant after this legislation, it can only be 0.5%, up to 0.5%. It must be redirected to actually improve the property, and it must stay compliant with all of the notices that are required. Okay, so just because this legislation passed didn't make the old ones that are more than 0.5% go away. As long as they stay compliant with giving the notices and re-record, they can do more than 0.5%. So Barb, the part I wanted to talk with you about is kind of the best practices, right? In your situation that you're dealing with, and I know you've had it a couple of times, and really the biggest part, I think, is a notice of caution, because what does this group send out for the new buyer to sign?
Oh, they've sent out a notice to the purchaser of a transfer fee obligation. They want the buyer to acknowledge they know they have to pay that when they sell it.
Yeah, and this is where, you guys, we're crossing a line here, and we're getting into an area of gray. This is real estate law. We are not attorneys. It's not our job to decipher whether the private property transfer fee covenant, I can't even remember how to say it, is legit, or if it carries on. This is where we should be advising our people that they should really talk to an attorney. Now, Barb, most of the time in the preliminary title report, are these things showing up?
Yes, and on ours, we've got a hyperlink, so you can click that blue link and go in and view the document.
Yeah, so I'm going to put on my paternal principal broker hat for the agents. It's like, listen, I know we get in a routine of doing the business, and we sometimes just, oh, it's the PR, and make sure I get a copy in the SkySlope, and sometimes we don't look at it. This is why we advise you over and over again to go through the PR yourself, sit down with your clients, and especially the exceptions, which are, is it section B2? Is that where those are?
B2, yeah.
The non-standard exceptions, the non-boilerplate exceptions, like, yeah, taxes and everything else. And is that where this shows up typically?
In my case, it shows up after the CC&Rs. Yeah.
Okay. So, you know, guys, whether it's a property service agreement, or in this case, a private transfer fee agreement, covenant, it all starts with us, right? People have hired us and are paying us a pretty good amount of money to be the Sherpa to help them navigate a transaction. Ultimately, they're responsible, but that doesn't get us completely out of the liability game. Our fiduciary of reasonable care is to put eyes on it ourselves and take a look at it. And Barb and I were talking about this, you know, right? So in section 6.1, it says that the seller is going to provide fee title to the property. They're going to basically deliver it, barring any encumbrances or any, clouds to title. And unfortunately, or fortunately, depending on your perspective, it dovetails with also what's up in section 4.3. Barb, when you see transfer fees, most of the time, where are those funds going? Is it going to an individual, or is it
Oh, it
going?
goes to the HOA.
It goes to an HOA.
Okay.
And I think that's where most agents are familiar, right? We're familiar with going to an HOA, an HOA, a reinvestment fee. There's like 10 different terms they can use. But what's different about this one?
It is not going to the HOA at all.
Yeah. As Barbara and I were talking about this before recording this, back in 2009, 10, 11, 12, there were a lot of builder developers out there who were losing their shorts on developments that they put a lot of money into. The market wasn't great. You know, this was the Great Recession. And as a way to perhaps monetize it and recoup their money over time, and since they owned all the lots at the time, they recorded into the CC&Rs that there is this private transfer fee covenant, which points back to in a lot of cases, the original builder developer who figured, well, rather than declare bankruptcy, I'm going to hang on to these properties. I'm going to push them through. We're going to get them sold. And over time, I will recoup my money because I know people are going to move and I'll get this private transfer fee. So just be aware, there is a difference between transfer fees or investment fees going to your HOA versus these private ones, which is going to whoever was declared originally on the document that is governed by this document, who gets those funds. And so anything that you feel, Barb, that they should, be aware of outside of the PR, obviously, as they move.
So in this particular case, that fee didn't get paid when my seller bought it. So he's now stuck paying both.
Yeah. So in both scenarios, the private service agreement and these private transfer agreements or property service agreements, these things aren't cropping up until in many cases at closing, especially if the agent isn't doing their job and throwing the flag early when there's still some leverage and there's still some daylight to get them resolved before we get to closing. And if in this case, your seller, apparently whoever did his original transaction didn't catch it. And so now there's two that he's required to pay. So coming full circle, I would highly suggest that you pay attention to these property service agreements. And then today's issue is these private transfer fee covenants. Pay attention to your PRs. If you have any questions about it, we have great personnel like Barb and Charlie and a lot of other people at Metro Title. And the good news about Metro Title is we have direct connection with these folks, and they speak very directly with us. They don't speak in code speak, and you'll be able to represent your clients better. So get your PR. When you see these things, don't just assume you know what it means. Go and talk to your rep at Metro Title Utah and make sure you get the information out early to your respective clients so that you don't have a big debacle at closing. Because I'm assuming, Barb, that the seller was super excited to pay 2 transfer fees at closing when he thought he was going to get a certain amount in equity.
Yeah, he didn't want to pay one of them, let alone 2.
He didn't want to pay 1, let alone 2. So you guys, thank you. I hope you have a good week. I hope this information is helpful, but it really is a reminder. Pay attention to your PRs and use title companies like Metro who know what they're doing and that you have established relationships with. And with that, I wish you a good week and a highly productive week. See ya.
Thank you, Matt.